happens when you get hurt, but you're a Medicare beneficiary? Who's going to pay for medical bills when someone else is responsible for causing your injuries? This comes up a lot in my practice. People who are on Medicare generally are senior citizens. However, if you are a Social Security disability recipient, you may also be a Medicare beneficiary. It all depends. But Medicare is a government entitlement. It is a federal program. It is taxpayer funded. So if you're hurt in a trip and fall at a mall or in a parking lot, and you're going to ask yourself who's going to pay for your medical bills, and you're a Medicare beneficiary, the working assumption you should have is that Medicare, your primary health care insurance in most instances for people who receive that benefit, will be responsible for paying those bills. So how does that factor into your case? It's become so prevalent. It's so common. I almost know it like the back of my hand. Medicare will have an irrefutable right to recover money the program paid on your behalf for anything related to your accident. That's the way it works. It's established in the law. Lawyers like myself cannot run away from it. You have to deal with it. It's evolved quite a bit over the last 20 years, and people like myself are actually affirmatively obligated. We have to notify the program, whether you like it or not, if you're my client, that there is a personal injury claim and that we are involved and that we are putting them on notice to send us updates about the basic meter, the meter that's running, the tally that's adding up of all the medical bills associated with your accident-related care. At the end of a case, we get a final number from Medicare, and there are certain things that happen that actually involve some reductions of what you have to pay back. It's formulaic to a large extent, and it factors in the things like attorney's fees and costs of cases. But the long and the short of it is this. My clients will have to set aside part of their settlement money to reimburse Medicare or medical benefits paid related to the accident. How much changes? How much varies from case to case? Sometimes there can be exceptions where Medicare will accept less than usual. And sometimes there are situations where they need everything up front, or not up front, I should say, but they need to be repaid as much in full as they can, but it's something that cannot be ignored. Does that mean you should not move forward with a case? Absolutely not. No, that should not be a factor in deciding to move forward or not. Advising Medicare of your claim and advising everyone involved in your claim or case, like, for example, the insurance company and the defense lawyers and even the judges when necessary. It could also be a basis for increasing or raising the amount of a settlement demand, or maybe in court, a verdict. We can add medical expenses to any ask we make of an insurance company, and if push comes to shove, a judge and a jury. So it's not a reason to not move forward, but it is a very important part of the case that cannot be ignored. Lawyers like myself and clients who think they can try and duck the law are going to be jeopardizing themselves in a big, big financial way. The law actually gives the government, Medicare is basically the government, the right to what are called the triple damages, if they find out about a case that wasn't reported to them, even if it was after the fact. The law is very protective of the government in these instances. It is perilous to try and play hide and go seek with Medicare in these matters. It's not worth it, and it's foolish. And under no circumstances would I ever recommend it. But it should not dissuade someone who is a Medicare beneficiary from moving forward if they believe strongly in their case and believe it will be overall worthwhile to try and find a way to make them whole.